Well, thank you so much for joining us for Murdaugh After Hours, where we are bringing you in-depth analysis of the big moments from today's pre-trial hearing. As many of you know, convicted felon Alex Murdaugh back in court today, not wearing the orange jumpsuit, but in an actual suit today, as a series of motions were discussed during the hearing today in front of Judge Deborah McCaslin. And joining me this evening to give a breakdown of those big moments, those key moments, which could shape the way this trial turns out in April. We have criminal defense attorneys John Mobley and Dane Phillips. Thank you so much for joining us.
Thank you.
My pleasure.
All right, so I want to start off with the very beginning, because a number of bombshells, big moments happened within the first 15 to 30 minutes of this hearing, one of which is something called Giglio. So for our friends who are watching, can you break down what Giglio is and what came of that today in the hearing?
Okay. So Giglio is a United States Supreme Court case that basically puts a duty on prosecutors to turn over any evidence that would go to the integrity of that specific state's witness. Specifically to this case, they bring up the personnel file. So if there's a law enforcement officer that's in a case that has prior disciplinary that goes to their integrity, whether they've mishandled evidence, whether they've lied on the stand, that would be kind of the epitome of impeachment evidence under Giglio that they would have to turn over. So any of this type of evidence that would go to the credibility directly of those state witnesses, the prosecution has to turn over.
We actually have those moments from court when this was discussed, and we're going to play that for you all in case you missed it.
So there's some items that we would have expected to receive by now, and we have not.
Let me know what those are. What are they?
So, as Your Honor well knows, the state has to produce evidence, information pertaining to, that the defense could use to challenge the credibility or truthfulness of a witness. It's called Giglio material, and it's in United States Supreme Court, Giglio v. United States, and these include plea deals and promises, secret agreements, evidence of witness bias, and credibility issues of police where there's evidence of past misconduct. And in that category, I have a few items. As to secret agreements, there's a co-defendant in some cases, and then he's been charged separately. His name is Eddie Smith. Curtis Eddie Smith, who's a distant cousin of Mr. Murdaugh, was charged on November 2021, almost 5 years ago, of ab-hand, pointing and presenting, conspiracy, filing a false police report, and that's related to a roadside shooting that involved Mr. Murdaugh. Subsequently, in June of 2022, he was indicted by the state grand jury of 4 counts of money laundering, trafficking in meth, of other things. 4+ years have gone by, and those cases have not been disposed of. Every other case that we're aware of have been disposed of. And it begs the question, why not? Do they have a cooperation agreement with Mr. Smith? If so, what are those terms? He has been identified as a witness in this case since the last trial, well before the last trial. So we've got nothing on Mr. Smith. And if they have a deal, they're obligated to disclose it. If they have an understanding, they're obligated to disclose it, and we've never received it. With regard to credibility issues of police, we are aware that Judge Roger Young dismissed a murder case, and the name of that case is State v. Michael Colucci, and he was indicted in 2015. In June of 2025, Colucci's attorneys filed a motion to dismiss the indictment, saying that the state withheld critical exculpatory evidence on the eve of jury selection. The motions identify David Owen, SLED agent David Owen, who was the lead case agent in this case, who after this case received SLED Agent of the Year award. Judge Young dismissed the Colucci case because of withholding of exculpatory evidence. We want to know what's in Mr. Owen's SLED agent, I think he's retired now, in his HR file Was he reprimanded? Was he sanctioned? Were any steps taken as a result of the Colucci matter?
All right, my friends, so you just heard some moments from them talking about Giglio questioning the integrity of that SLED investigation, members who were involved in that SLED investigation, also talking about the situation with Cousin Eddie, as many people call him. Tell me your thoughts of what we just heard from the courtroom.
You know, regarding Cousin Eddie, you know, in some of these issues, my first thought was I can't imagine these issues could not have been resolved directly with the prosecuting attorneys. I don't believe Cousin Eddie was a witness in the first trial. So on one hand, the question I would have is, and I can understand why they'd want it, but on the other hand, if he's not a witness for the state in the case, then you can't impeach someone that they're not going to call as a witness. So while I understand in general why they would want the information, the question I have is how useful it will be unless the state plans to call him as a witness, because again, it's useless if they don't call him as a witness unless they themselves want to call him somehow and then guess impeach their own witness. So again, those are my initial thoughts on the issue with Cousin Eddie. I think that's a red herring. I think if there was anything with Cousin Eddie that was relevant, they would have found it by now. So, you know, regarding the SLED witnesses, I think that is definitely significant. Because, you know, and I want to be clear, it's significant if this particular SLED agent had a substantial role in this case and engaged in conduct that was instrumental in the determination that Murdaugh was guilty in this case. So that's the big thing. I mean, obviously, yes, they should have any information out there that he has a history of engaging in misconduct by deliberately, you know, burying evidence, failing to disclose evidence, incompetence, dishonesty. All those things are relevant for any law enforcement investigator. However, in order to give it some real meat, he's got to have some role in the case where, you know, his credibility based on his role in the case calls to question the reliability of the case. You know, the case that comes to mind is Mark Fuhrman and the O.J. Simpson case. You know, Mark Fuhrman being the racist. Well, that was relevant, but that was relevant because he found the bloody glove. He was the one that said he found the bombshell evidence that tied the defendant to the crime. So his history for setting up, you know, black defendants, being racist, being dishonest, that was directly relevant. But if he was just someone that just showed up on the scene and gave a few took a few interviews and didn't do anything else, then it's not going to get a whole lot of traction.
Dane, one of the things I want to ask you about is SLED's investigation being called into question. I mean, this isn't the first time that the defense has said, we do not think that they operated above bar. And so do you think that this is something that the defense is going to continue to hone in on, is questioning the credibility of this investigation?
Yes, obviously prior to the first trial, there was the issue regarding the blood splatter on the t-shirt, and this came up in terms of the DNA motion about how SLED would handle the evidence. I thought that was going to be used more and more effectively in the first trial. Turned out that wasn't as much as a defense, you know, it's not a theme in and of itself, but it's certainly an avenue of cross-examination and attacking tunnel vision reliability of the state's investigation. I was surprised during the first trial that it wasn't used more. However, clearly the defense is going heavy into this lack of investigation or misuse or misrepresentation of how the investigation's been done. In and of itself, I don't believe that's an appropriate theme to win, but I do think it is a overall part of the defense probably strategy in attacking the integrity of the investigation to show here are all the reasons why reasonable doubt exists. However, my opinion is you can't win a murder case just by arguing reasonable doubt. You got to have an actual theory of defense. But it's clear that they are focusing solely, at least from these motions, in attacking the integrity of the SLED investigation. It's another reason why they've argued in the DNA motion that they don't want them to retest it. The fact that they've sat on this evidence for many years and have never done these subsequent tests, and now only in response to the defense's motion to conduct an independent review of the DNA evidence, do they want to conduct their own test, a test that which might destroy the defense's ability, the evidence and the defense's ability to conduct an independent review of that evidence. So again, I think there are a lot of credible arguments the defense has in attacking the credibility of the investigation. Now, how all that plays out in trial and how they use it strategically remains to be seen, because there all needs to be a means to an end. It's got to make sense to the jury, or it just looks like you're just complaining about things that don't make a difference as to whether the jury can certainly understand elements of murder, right? What goes to proving whether or not the state has the evidence to prove the murder in a largely circumstantial evidence case, and that's partly why they want to do that.
And I agree with Dane. I think that the two big things that come to mind regarding attacking the investigation in this case is that, I would definitely argue and attack that, there were a number of other potential suspects, people that have made death threats to this defendant based on his prior crimes and prior conduct, that they failed to truly properly investigate as suspects. So they conducted a biased investigation from that standpoint. And there was no real strong physical evidence tying this defendant to the crime. So when you have two very violent, bloody murders in a crime scene, and you have no real physical forensic DNA evidence connecting this defendant to the crime, and you have evidence, forensic evidence you chose not to test, that shows bias in the investigation and unreliability regarding the conclusions the investigators reached.
Another bombshell moment that also happened was shell casings. I'm sure if anybody's been following this, those two words caused quite a stir, because the defense said that they got a tip based off of a local media source that there were shell casings in another murder that were connected to shell casings in the Murdaugh murders. For anybody who missed that moment, we want to play that again for you so you can be caught up and understand what we're talking about.
We have learned through reporting from Fitz News that there was a recent murder, we believe, in Allendale County. And what has come out of that investigation and what has been leaked to the press is that Murdaugh murder weapons were connected to the Allendale County murder. Now, how could that be? And so we would like to know, were Murdaugh murder weapons connected to this Allendale murder? Now, if Your Honor will get into this, you'll learn that the SLED agent ballistic forensic lab did an analysis of just the shell casings on the 300 blackout that was used to murder Maggie Murdaugh. And the ballistics expert testified that the extraction marks on those shell casings found at the murder scene matched extraction marks found on shell casings around the Moselle home and at a shooting range. And their analysis was, in his opinion, it was the same gun that injected the shell casings of the 300 blackout at the house, at the driving range, and at the murder scene. Which leads us to, we don't know if it was the same murder weapon in Allendale, but if they did an analysis of the shell casings in the Allendale murder case, and they're saying it matches the shell casings for the Murdaugh murders, either their test is bad or someone's out there using the gun to murder other people. And so we would like that information.
All right, so John, you are shaking your head through that whole statement that Griffin was giving, the defense attorney. Give me your thoughts.
My thoughts are, and I'm going to call it like I see it, Jim's a good friend of mine. I love Jim to death. But if I was trying this murder case or any murder case, I would be embarrassed to go in front of a judge and say, hey, my theory of the defense is based on something I heard on a podcast where something might be related. I mean, I would expect the judge to shut me down to Chinatown. Give me something substantial. If the right thing to do, if you believe that is a relevant method of inquiry or area of inquiry, you got subpoena power. Issue subpoenas. subpoena the file, look at the evidence, subpoena the physical evidence, see if there's anything to work with. That's what you do. But to go in front of a judge and say, hey, I was listening to a podcast and somebody said in the podcast, this might be connected to this case, give me that information, I just don't think that's proper preparation. I think we need to do our jobs. I mean, I just, that dog don't hunt.
Reckless a little bit for me. This should have been phone call, email to the state saying, we've come across this information, we need to know whether there's any validity to this, respond. Or they easily could have put it in a motion, a supplemental motion of discovery saying, here's the source of the information. Obviously, it is just something that was posted online on a news media outlet, but we have no base for this, but we are made aware that this is out there. Respond. And you file that in a motion, you send that in an email, and the state's response. Just throwing it out in court without at least making the request prior to the hearing, I would not have done that because I think we discussed SLED has since issued a statement saying that they've put it into the national database and that it was not a match.
And I think, you got to keep in mind, they're fixating on one statement made in one podcast. As we know nowadays, I mean, true crime is an industry. There are so many podcasts, so many things on social media where people are putting out unvetted, unreliable information, things they heard third hand and fourth hand, things that are not supported by facts, things that are not supported by reliable evidence, and they're putting all that stuff out there. And it goes both ways. And I think if the prosecution had come in court and said, hey, we saw a TikTok video that said, we got evidence that Murdaugh did this, we want to use that, the defense would lose their mind saying that's unreliable, that's not evidence. So it cuts both ways. I mean, I've said this, I love what we do, but cases are won in the courtroom, not on social media. You get that evidence. And although Dane says, he could ask the prosecutor, subpoena. Don't ask him, subpoena. You can subpoena the file. You can interview witnesses. You can do all those things to conduct a legitimate investigation. You don't go into court with some half-baked theory about something you heard on the podcast.
And another big moment, polygraph. In fact, it was such a hot topic. I want to point out that at some point people were calling it the P word in the hearing today, saying don't bring up that P word. Judge McCaslin did rule about the polygraph. So in case you didn't get to see, basically the defense brought up that a polygraph was taken by cousin Eddie and he failed. A polygraph was also taken by Alex Murdaugh and he passed, and they wanted that to be used during the trial. Listen in to that argument.
Said there's not an absolute ban. There are circumstances under which a polygraph could be used. Again, it is not a lie detector, but the question is, if somebody was confronted with the fact that they failed a polygraph, did they give it? In this case, did they give it a confession? The Eastwood case, it was a confession gotten. In this case, and we want to argue this more fully depending on whether or not this witness is called, Eddie Smith, who, as we've already understood, was charged with a whole bunch of stuff, had a proffer agreement with the state, and the proffer agreement was conditioned on him passing a polygraph. And as Mr. Waters knows, in other words, he had a deal, and the deal was predicated on him passing a polygraph. This is a copy of the results of that polygraph. And the polygraph was, did you kill Paul and Maggie Murdaugh? He failed it. And so they, relying on that, canceled his proffer agreement. Now, I'm not saying necessarily that's admissible on cross, but I am saying that it's an issue, not now, but much closer to trial, that we need to be able to litigate. And there may be others. We're going back through, I will tell you, Mr. Murdaugh passed a polygraph, flying colors. So, the same polygrapher. So, it may play a role in this trial. I'm not willing to concede that not under any circumstances can a polygraph ever be used. I'm just giving you this example of Eddie Smith failing the polygraph and them relying on it to cancel his deal. Now, that's what our understanding is from the limited documents. They never called Eddie Smith in the first trial. which we were shocked by. But should they call him in the second trial, we may want to go into this. But so I would ask you not to issue an order prohibiting any mention of polygraph with this guarantee. We would not mention polygraph in a courtroom with a jury until given permission by Your Honor to do so.
Judge Deborah McCaslin said basically at the end of that, do not use the word polygraph during this trial. And if you feel like it is necessary to bring that in, you have to get permission from me. Talk to me about the importance of the polygraph for the defense and why the state would not want the polygraph involved in the trial.
Well, one, polygraphs are generally not admissible. They are not reliable to the sufficient method to allow them to go before a jury. Big issue there for the defense is the investigation. There's a fine line of where we're touching on third-party guilt, and we discussed earlier the admissibility of all that. But the defense has the ability to attack, as we said, the integrity of the investigation, and specifically to cross-examine about the issue of had they investigated, had they interviewed every potential suspect. Now, whether they say Cousin Eddie is a person of interest, which is different than a suspect, those issues that we know, the specific question is, did you kill Maggie and Paul Murdaugh? And he had deceit. The judge properly ruled to keep it out. But I believe the defense is going to really toe the line about where they can go in cross-examination about their investigation into Cousin Eddie's involvement. And in many respects, we discussed earlier, that's probably going to backfire on them because the state will pivot and say, well, that's because Murdaugh and Cousin Eddie did it, potentially, because nothing locks the prosecution into what they argued in the first trial and doesn't lock them in even in a second trial to pivot and make multiple arguments. Prosecutors can make multiple arguments in a case. And so in terms of what their theory of prosecution is, it is a pivotal point depending on, again, we're now chasing this DNA motion about whether they'll be able to have sufficient evidence to argue third-party guilt. But as of right now, the guardrails are very, very tight. They will not be able to mention polygraph, and I think that's proper. The big issue is how much of a leash is Judge McCaslin going to give them on cross-examination related to Cousin Eddie and while they're cross-examining the investigator. I doubt that you'll see Cousin Eddie in the second trial. I believe he's a unpredictable witness for both the state and prosecution and the defense. It's a situation where, as a lawyer, you never want to put up a witness you don't think you can control. And if the prosecutors don't believe they can control him and the defense doesn't know exactly what he's going to say, you generally don't call that witness because it could severely impair their case. Because, again, the issue about what we just heard that strikes me the most is the fact that Dick Harpootlian said he believes they had a proffer agreement. So if I was the judge, my question would be, you're saying that they had a proffer agreement. What evidence do you have to support that? Because the state's position is that that agreement never existed.
Right.
That's a big allegation. That is an ethical issue because now you have a discovery violation, you have multiple issues that come up from an ethical standpoint. So the real question is, what evidence do you have that a proffer agreement existed? That's where I would, if I was the judge, really would have said, but you need to tell me if you believe that, what do you have to support that, to make that statement? Because that is an ethical issue, a discovery issue. The next big thing is, it's rare that the prosecution gives proffer agreements to potentially a big witness, especially like that, because the defense can use it on cross-examination. Many times these witnesses are interviewed, and again, as a defense attorney, we don't like it because there's the argument of a wink and nod type agreement where there's nothing in writing. But, and I assume that's where the implication is from the defense, that they have an understanding. So specifically for me, my discovery request, if I was the defense, would say I want all the emails and communications between the Attorney General's office and the lawyer that represents Cousin Eddie. That would be the more interesting piece of discovery that I would want, because that's where you get, potentially there's not a contract of them working together, but some communication about, well, is he coming in to speak? And you may get some other things that you could use on cross-examination, because I doubt a proffer agreement exist unless they have some credible evidence that it does.
And I want to say this too. When Waters responded, it was a very passionate response, because you can very
It's a
much,
shot over the bow.
Yes, you could very much tell that, and I don't want to speak for his state of mind, but from the outside looking in, maybe even slightly offended that they would say that there was
a discovery violation. And
Yes.
when he alleged that there is a proffer agreement and they don't have it, that is a discovery violation. Not only is that its own legal issue in court, but that is an ethical issue as well.
Absolutely.
And I still think with that, I mean, all that's very interesting, but as Hart Pootlian said himself, Eddie wasn't even called as a witness in the first trial. I mean, and I can guarantee you he's not going to be called as a witness. He can assert the fifth. I mean, even if they wanted to call him to testify, even if they thought he's reliable, he could still assert the fifth because he has zero to gain from getting involved in this case. So, I mean, obviously you got to do your job, but I mean, I think it's much ado about nothing, because again, let's assume they get all this information, and okay, there's no proffer, Eddie made statements, Eddie lied about this, Eddie lied about that. Well, if he doesn't testify, you have information, you can't impeach someone that doesn't testify. So I guess the next question becomes, okay, well, can you use that to make a legitimate argument for third-party guilt, because you have this person that gave statements that were dishonest and you know, he lied. There still has to be something that kind of ties him to the murder. Mm-hmm. The fact that he's a liar and unreliable and gave inconsistent statements, and you know, there still has to be some nexus to tie him to the murder. So I think they're putting a lot of work in this thing, but the question I really have is where that's going to get them.
And another motion that I want to talk about is the testimony from the original trial. Now, we've been talking about it for days, as this is one of the newer motions that was filed. The state saying they want to be able to use Murdaugh's testimony from the first trial in the new trial. And this is a pretty much cut and dry argument here. The state is saying this needs to be used. He swore under oath, and so therefore it should be admissible in this next trial, whereas the defense is saying, well, if this is a new trial, then why are we bringing up old stuff, right? And so I want to hear y'all's perspective on the arguments from both the state and the defense and the role that that testimony could play, because the judge ultimately decided that his original testimony in the first trial could be used to an extent.
It's a legal issue from the defense side. And this is where John and I disagree. I believe that it should not be admissible in the state's case in chief. In other words, the prosecution should not just be able to present his testimony for many different reasons. One, you have significant cross-examination on the financial crimes issue. We know that, at least from the South Carolina Supreme Court opinion, that it's going to be limited in scope. So we already know that the statement itself is going to have to be redacted in some form or fashion. It creates another appellate issue, another legal issue that we'd have to deal with on an appeal down the road if convicted. To me, the right thing to do is treat it like every other statement. Would be, if he testifies, you impeach him with that statement. If he testifies differently, you're able to cross-examine him on all those things. But to me, there is a legal argument that it has legitimacy in the fact that I've read the defense's motion on this, they made great, painstakingly specific arguments that his decision to testify and their advice to him about whether to testify was based on the fact that we had all this financial crime testimony, what we call prior bad act testimony, that had all that not came in, and I believe it was 10 days worth or 12 and a half hours worth of financial crime testimony that at least our South Carolina Supreme Court has identified to be certainly problematic under the law and should have been narrowed in scope. Because of that, their advice and his decision was based on that issue. And so had the case been tried differently, in other words, the financial crime evidence didn't come into trial, he might have chosen not to testify. So I think the right thing to do would be to reserve his testimony and use it as impeachment. I understand he made prior statements, but his decision to testify was made based on the fact that all this arguably inadmissible evidence came in at that trial, and he had to address it. Particularly character assassination evidence that doesn't go to one piece of evidence or element of murder.
Well, I agree with Dane saying that we disagree. I mean, and a couple things. One thing I want to make clear, I want to address is, and I've read the opinion. I've read the appellate opinion, and one of the biggest areas where we disagree regarding what the Supreme Court said about the evidence and the admissibility of the evidence of the financial crimes. Okay, the Supreme Court did not say it was error to admit the financial crimes. They did not reverse the conviction based on that. The conviction was reversed based on the conduct of the clerk of court, Becky Hill. They did address the admission of the evidence of financial crimes, and they indicated that in a retrial, the trial judge needs to be cautious about how much of it he lets in, because, based on relevance, but there was no specific decision or ruling or order stating that was inadmissible. It was not inadmissible, okay? So I think that's the first thing. So next, as far as, what the state wants to include from his testimony, they don't care about his testimony about the financial crimes. Nobody cares about that stuff. I mean, he stole the money. I mean, that's not even in dispute. He stole the money. He pled guilty to stealing the money in federal court. I mean, it was overwhelming evidence that he stole the money. The relevant evidence from his testimony is that he lied to the police. He lied about being at the crime scene. He told the police that he was not there. He told his own lawyers he was not there. It was only once his voice appeared on the Snapchat that he got on, and honestly, I would disagree with Dane. I don't think he got on the witness stand because of the financial crimes, okay? He wouldn't worry about that. He wasn't on trial for that. What was he gonna say? I mean, oh my God, I'm so sorry, I didn't steal all the money. You stole the money, you're not remorseful. He got on the witness stand because he got up there in opening his lawyers and said he was not there and had an alibi, and the state played a Snapchat with his voice indicating he was at the crime scene. That's why he testified. So I do believe that he made a voluntary statement on the witness stand in open court, under oath, with the advice of counsel, a choice he made, and he testified. That should get in. And ultimately, when you testify, you do so at your own peril. So I think, that ship is kind of sailed for him, and I think that's the right decision. I don't think the state needs to even worry about the financial crimes. They're not trying to admit any evidence, I don't think, from his testimony about the financial crimes. Nobody cares about that. What's relevant is him lying about being at the crime scene and admitting he lied to law enforcement.
Two criminal defense attorneys, two different opinions. I love it, because I think this is a real conversation that a lot of
prosecutor.
people.
That's a prosecutor.
Hey, I got to call it like I see it.
That's a prosecutor's argument.
But I love it because I feel like this is a conversation that a lot of people are having, and not everybody is going to agree, right? And so I think this represents what people are talking about. Something else that people are talking about, and we've been talking about this for a while, DNA. Everybody's been wanting to know about what's going to happen with that DNA that was found under Maggie Murdaugh's fingernails. So in case you haven't heard about this, basically there was DNA that was found that was linked to an unknown male. The defense is arguing that they want to take the leftover DNA that has not been tested, give it to a third-party agency organization called Othram, and have them run tests. And the state is saying, we want to keep that DNA and continue to test it as well. And so what we're going to do is allow you to listen to part of that argument regarding the DNA and what will happen with it.
We have extract, and we also have the unprocessed sample. And so what we have, and we've had a discussion with their expert, and he said, that's barely even a mixture.
They've had 5 years. And we're on appeal for a while, but from 21 to 23, they did all the testing they wanted to do. And now we've come up and asked to test it, and guess what? Oh, we want to test it. Well, they've already tested it. And now because we asked to test it, they want to take control of our testing? I mean, that's not fair.
And that is a short soundbite, but it is one of the most powerful sound bites in that conversation, because it really sums up the argument that the defense has. So tell me your thoughts when you were learning and hearing about this argument about that DNA evidence. Where is the state's position on this? What is the defense's position on this? And it's important to know, ultimately, Judge McCaslin did allow the defense to be able to send that leftover DNA to Othram.
It's hard to me, for the state to argue with a straight face that they need to retest this when it's set in their possession for 5 years, and it's only in response to the fact that they want to do an independent testing. He has an absolute right to conduct his own independent review of this forensic evidence. As we discussed earlier, one of the primary 5 issues of exonerations for wrongful convictions is misapplication of forensic science. Now, we haven't even got to the application part because we haven't done that investigation. The defense lawyers have an absolute duty to conduct a full, reasonable investigation. When you have unknown male DNA under a murder victim's fingernails, this should have been done prior to the first trial. That's on both the state and the defense. These are all arguments that should have happened 4 years ago. But here we are now. The defense has a legitimate, reasonable argument that they want to have independent testing at a facility that does a higher level, more accurate, arguably, test than what the state does. And that if you allow the state to retest it under the current method that they use, that evidence could be destroyed in the process of testing and would prevent them from being able to retest it. It is a legitimate argument. I certainly think the judge made the right call in allowing the defense to conduct the independent DNA review, given the issue. But with the 5 years that the state had, they have no inclination to do this. They just want to have full control. And of course, if the evidence somehow gets destroyed while they're processing it, that's too bad, right? This, to me, was an easy call for Judge McCaslin to allow the defense. What Jim Griffin said about this isn't fair, the whole reason why he's got a new trial is fundamental fairness under the Due Process Clause of a right to a fair trial. There's no reason to deny his ability to seek an independent review when the state's already tested it. They don't need an opportunity to retest it and to potentially destroy evidence.
And of course, I got to call it like I see it. I agree with Dane, but I disagree with both the state and the defense. I mean, I think I agree with Dane from the standpoint of, the state had every opportunity to test this evidence again. They chose not to do it. So to try to raise issue with it right now when the defense wants an independent test, that dog doesn't hunt. I mean, you had your opportunity. It clearly wasn't a big deal to you. The reason I disagree with the defense strategy is I have been in that situation where I've had a client on trial for murder and there's evidence that has sat there for years untested, and at first you get excited, your true crime buffs, you get excited, hey, we found this evidence that hasn't been tested, and you have this idea in your mind that testing it's going to somehow exonerate your client. That rarely actually happens, okay? And the problem the problem I have with that strategy by the defense is, that they don't know what that test is going to establish. It could come back as their client. They can't believe a word he says about being there because he's already lied to them before. He lied to everybody else. So I wouldn't make a decision based on that, okay? And the second thing is, let's say they can identify another suspect or another individual who contributed to that DNA. Well, that doesn't necessarily mean that their client's innocent. More than one person could have committed that crime. Quite frankly, Whitney, I think it's more likely that more than one person committed that crime. I believe a much better strategy, instead of all this showboating, I'll say it all the time, you win case in the courtroom, not the newsroom, okay? A much better strategy would be, during the trial, to drop that bombshell in front of the jury. You have that lead investigator on the witness stand, you have him admit that they found DNA under this lady's fingernails and they didn't test it, or the test they conducted didn't yield any results, and why didn't you test it again? You get them to admit there's a more reliable testing process in place. It could be tested. You chose not to test it, and now you have the jury asking that question: why didn't they test it? That's a lot more effective. And I think so if you want to raise reasonable doubt and attack that investigation, like I said earlier, attacking the integrity of the investigation, it's much more powerful in that context than having it tested and a lot cheaper.
And I think that so many people are going to be very interested in the results. They said it could take anywhere between 60 to 90 days, maybe more. Griffin said that, Othram even said that they will put this on the top of their list of things to work on. And so a lot of people are going to be waiting to see what comes of that third-party testing, because that, I feel like, has the potential to change the trajectory of what ends up happening in trial. Even though I know you're like, we don't need the testing, we need to create
But I think the other question I'd have is, even if, notwithstanding the result, you know, if this is a very new and novel testing process, the question becomes how reliable is it in the scientific community such that it can even be admitted? So that's why I just think they have more to gain by just leaving the question out there for the jury and have the jury upset with the investigation and thinking, hey, we can't make a decision because they didn't do their job. Because, you know, once you know, when it comes to taking and having an independent test done, I tell all my clients this: I can get the test done, I can get the expert to do it, but I mean, we can't control the result of the test. And once you fire that bullet, you can't put it back in the chamber.
And correct me if I'm wrong, I believe the lab that is doing this third-party testing is the same lab that was used in the Brian Koberger murder, the College, Idaho murders. And so this is definitely, like you are saying, it is new and it is up and coming. So I'll be very interested to see how that plays into this, this trial. Now, another big thing that we were waiting to hear, where is this trial going to take place in April? You know, a lot of folks are very interested in this. There are a lot of people who want to go ahead and book a hotel room because if we're being honest, there are so many people who are invested in this case. They want to show up and they want to be there. So what we did learn is that Judge Deborah McCaslin did not decide where it would be. However, she did say that it will not take place in the 14th Judicial Circuit in order to protect Murdaugh's constitutional right. And so I don't think that came as a big surprise, right? That she said this is not going to happen in that 14th Judicial Circuit. And so my question would then be, well, where will this take place? Murdaugh's defense team is asking for it to happen in Charleston. They're really pushing for Charleston. The state is saying, no, it's too costly. The logistics around it would be too complicated. So tell me your analysis of the conversation regarding that venue change.
Well, to me, the first thing I'm looking at if I'm in the judge's shoes, are we focused on trying to find a county that has similar demographics as Colleton County, or are we focused on the other issue, which I think is a massive issue, the financial cost of this retrial? Having it local, say in Lexington, certainly saves a significant amount of money because you don't have the entire Attorney General's office just about in SLED staying in a hotel for a month long. I could imagine what that hotel would be in Charleston, in addition to all the other states' witnesses that they're bringing in. So just from a cost perspective, but also when you have similar demographic counties, you have these rural courthouses that don't have appropriate technology, which certainly can be addressed, but again, financial, appropriate security, which certainly can be addressed, but financial. It makes no sense to have this out of town. And when I say that from the Midlands perspective, and of course I'm biased, I live in the Midlands, and I'm a criminal defense lawyer, but it just doesn't make sense to me. I know the state had proposed Spartanburg, York County, Florence. They proposed really conservative jury places, whereas the defense proposed Charleston, and of course you could say Richland, which would be more liberal jury pools is what they would say. So obviously I don't think anybody's going to get what they want. Like most things in life, there'll be some type of compromise and there'll be a county picked that's probably not on the state's list or the defense's list. However, demographics should play some role if you're trying to really keep it close to the law. The level of publicity, that issue by itself is not the reason for the change of venue all in of itself. The judge made clear in her order addressing those points that it's not just based on publicity, it's based on all the factors that happen with the clerk of court's office and the Murdaugh influence in that area. She made the absolute correct decision to get it out of that circuit. The big issue is where. I just think the simple, easy answer is to keep it in Lexington, where you have a newer courthouse with ample parking. It's a big enough city that can take this. I mean, it's a media circus, international case. It's going to be a massive undertaking, a trial that will probably, it lasted 6 weeks during the first trial, probably last a month in the second trial. I think it'll be a little bit less, tighter case on the state's side, might actually be longer on the defense side. I certainly anticipate potentially the defense may be presenting a completely different case. Lexington takes it one step removed from Columbia, where the South Carolina Supreme Court is and all the major players are from and where they work. Debbie McCaslin is one of the resident judges in Lexington. These hearings have been in Lexington. It just makes sense to me that that's where it'll stay. But I could completely be wrong, and she easily could pick any of those other counties. This is a unique situation.
I cannot disagree with Dane's analysis. It's very rare that I'm speechless, but in this case, I have to say that I agree with his analysis.
Oh, and I also want to have a conversation about this.
But I do agree, and I just want to add that I think he made an excellent point that, the change of venue really, I don't think is the publicity and pretrial publicity, I don't think is an issue because everyone's heard about this case across the country. So you're not going to find people that haven't heard about the case. But I do think that the fact that the first trial was reversed based on misconduct by the clerk of court in that county is significant. I think based on that, it's best not to have that trial in the same county where that same staff is somehow involved in interacting with the jury and making decisions. I just think that that would seem somewhat inappropriate and give me some cause for concern. So I think that reason alone is a significant reason to justify a change of venue in this case.
And I want to end by asking this question, and it's something that you and I had a little disagreement on regarding public perception. When it comes to picking a jury, how important is Murdaugh's public perception? Because there can be an argument that some of the reason that Harpootlian brought up the shell casings and the credibility of law enforcement was to create a different narrative for Murdaugh, maybe start planting some reasonable doubt in the public for Murdaugh. So talk to me about, and I want to hear from you both on this, how will you think public perception of Murdaugh play when it comes to picking that impartial jury?
All right, I got a few opinions on this one. I think, when you describe some of the things that Harpootlian has done, and Dick's a very intelligent attorney. I've known Dick my entire legal career. He actually gave me my first job, not as a lawyer, as a law clerk even, out of law school. So me and Dick go way back. I've had many dress downs in his office when I was a young prosecutor full of myself. So, however, when it comes to some of the motions that he's making, I've said there's been so much grandstanding in this case. A lot of sizzle, not a whole lot of steak, a lot of show for things that really don't go anywhere. That's kind of gone on throughout the case. So I don't put any real significance on that from the standpoint of his intent to try to change the narrative. As far as making the public more sympathetic to Alex Murdaugh, good luck with that. You're trying to get sympathy for the devil. The man is that's just not going to happen. You can take him out of the shackles and put him in a suit, but guess what? He's still Alex Murdaugh, Now, also from a strategic standpoint, like you hear me say, cases are won in the courtroom, not the newsroom. When this case goes to trial in 6 months or so, and 12 jurors and 2 or 3 alternates are seated, no one is going to be thinking about some 5-second soundbite that was made 6 months earlier after they sat through 8 hours of testimony across a month or a month and a half.
Yeah.
Okay, that's not how it works. I truly believe that all these things you may consider a bombshell, I think they're much more effective when you save them for trial for 2 different reasons. Number one, they're more effective in front of a jury that's going to make a decision in the case. Because juries, when you have these long trials, juries have short attention spans. They're not going to recall all these details that the lawyers, we think we're so smart. We think that, we fix it on these details we think the juror keys in on. They generally don't. They have feelings about the case and intuition, but they'll remember a big moment in the trial that impacts them emotionally, just like you're being impacted by seeing what happened on TV today. So it's much more effective in front of the jury at the trial as opposed to 6 months earlier. Second, when you make these motions and you know you don't have a very good chance of winning them, the problem with making them so far in advance is you give the prosecutors a heads up of whatever your bombshell is going to be. So now when the trial comes, they're prepared for it. I've always believed as a criminal defense attorney, my biggest advantage when I stepped into the courtroom was the element of surprise. If I could drop something on the prosecutors they were not prepared for, they did not expect, now they're scrambling. Now they're reacting. Now they're trying to, redirect their own narrative to deal with my issues and my bombshells. That's a much more effective way to use these bombshells for those reasons.
I think a lot of it, I don't believe you move the needle much on the narrative. It's well settled between documentaries and everybody who watched the first trial. People have their opinion about Alex Murdaugh.
And they're sticking with it.
A couple of comments in a motion hearing is not changing anybody's perception of him. I think the issue will be, is the Murdaugh team conducting the investigation potentially that they should have done in the first trial for what I'm one of the lawyers that handles post-conviction relief cases. It's where you argue as far as ineffective assistance of counsel, and maybe they're making sure they're tying up every loose end so they don't have to answer those questions if he's convicted in a PCR hearing. Because again, if you had this unknown male DNA and the defense doesn't push to have it tested, then a PCR lawyer could have it tested. If it came back to somebody that could have changed the defense strategy, that could give him a new trial in and of itself. So are they trying to close up some of those, tie up some of those issues that should have been resolved prior to the first trial through an investigative manner? Certainly, John's position is a strategic one, which is what many defense attorneys testify in these PCR hearings. I've made this decision for a strategic reason, and he provided his full strategic reason why he wouldn't have sought to have that DNA tested. I think a lot of it is the investigation that potentially should have been done the first time. Again, there's all this additional information. I think we're in the age of, as we talked about earlier, podcasts, and everybody's got a theory, and so you have so much speculation and innuendo, but we deal with direct evidence, and you have to investigate what's real. The fact that a online news media posts that there was some sources say that there was a consistent match, but now SLED has shown that that is not true potentially, that hurts my credibility in the courtroom. I want to make sure that when I'm in the courtroom and I'm standing in front of a judge, that I am the most credible person in the room, that when I make an argument, whether it's a legal argument, whether it's a motion related to a specific thing, that the judge is going to listen to me and not shut me out, because they know that, one, I know the law, and two, I'm credible in the arguments I'm making. If I make arguments that don't have any backing, any basis for it, the nexus arguments, then the judge is going to tune me out half the time, because they're going to say he's just making these random arguments that aren't going anywhere. So I think, for me, a credibility standpoint, there would need to be legal motions filed before I just throw out there that potentially there is this connection and match. I think, look, we could go for days about, I think there should be a challenge on whether or not they can say the shell casings were consistent with or a match. There is challenges on the Innocence Project and from around the country on whether that subjective nature of testimony should even be allowed as an expert. So there's so many different layers to this issue, and every lawyer tries it. You get 10 different criminal defense lawyers, you could have 10 different defense strategies and how they try a case. That is the interesting thing about what's the practice of law. It is not a science, and everybody has their own opinions. There's a million different ways to do it, just like 12 individual jurors could make a completely different decision than 12 other, every jury can come back differently. That's the interesting thing of how this is going to play out. I know they have a few more hearings. I think the judge is going to hold their feet to the fire to that trial date. So the interesting thing is, where does this go? What do we get back on this DNA evidence? This allegation about the shell casings, is there any evidence to show that that was actually even a valid thing to bring up in court? It sounds like SLED saying there is zero credible evidence related to that. Next thing is, again, the issue related to this proffer agreement. Is there any basis to say that you believe a proffer agreement existed? These are issues that if I'm presiding as a trial judge, that I would have really hammered. When things like that are said, I want to make sure there's some basis to it. And then if so, let's dive deep into it. And I think some of this stuff has been kind of high level that needs to even go a little bit deeper in the weeds. You can't just make allegations without some type of supporting evidence.
I agree with Dane. I mean, when I step into a courtroom, whether I'm addressing the judge or addressing the jury, I want to make sure they know that anything Mobley says there's going to be a reasonable factual basis to support it. That is so important, not just for the issue that you're arguing, but throughout the entire case. Because if the judge or the jury thinks you're the type of attorney that's going to just say anything, you will just make broad, baseless generalizations for which you can't back up, for which there's no evidence. They're not going to believe you. You're not going to have any credibility. They're not going to listen to you. They're going to tune you out. But over the course of the trial, if they know, hey, if this person says something, I can take it to the bank, that pays dividends for you and your client.
All right, my friends, you heard from Dane Phillips and John Mobley, two criminal defense attorneys, breaking down what happened in today's pretrial hearing. A lot happened. We got some decisions, but still a lot of questions, all of which could, again, determine what the retrial will look like when it takes place in April. Now, we are going to continue to follow the very latest on this Murdaugh retrial online and on air. But until we have that another pre-hearing, another pretrial hearing, it's going to be happening in just a couple of weeks. But until then, you can stay up to date again, both on air and online. Thank you so much for joining us for WLTX After Hours. We'll see you again.